Good morning. We can go ahead and unmute, please. Thank you. Good morning, everyone. This is Board President Vasco Dion Kidd of the California Physician Assistant Board. I'd like to call the meeting to order at 8:30 a.m. on August 15th, 2025. Ms. Hur, will you please call the roll?
Juan Armenta,
Present by video.
Eric Bergenson,
Present.
Philip DeVizio,
Present.
Diego Insunza, Vasco Dion Kidd,
Present.
Edwin Perez, Bhavna Prakash, present, Deborah Snow, present, Viling Sai,
Here.
and that concludes the roll.
Thank you so much. We have a quorum and we will proceed. The first item on the agenda is consideration and approval of the April 21st, 2025 board meeting minutes. I trust that everyone has had an opportunity to review the minutes. Are there any additions or corrections from the board? Hearing none, I would assume, right? No one has any corrections or edits, just to make sure I confirm. Okay. Do we have any comments from the floor or from WebEx? Just to make sure, did the moderator open the queue for WebEx?
Thank you. So I'll always wait for people in the room to make their comments first, and then we'll go to WebEx. Right now, we don't have any members of the public logged in, so I return the floor back to you.
Thank you so much. It doesn't appear that we have any comments from the floor. Is there a motion to approve the April 21st, 2025 board meeting minutes?
So moved.
Is there a second?
Second.
Thank you so much. Do we have any public comments on the floor or on WebEx?
This is the moderator. No comments from WebEx.
Thank you so much. And with that, the April 21st, 2025 minutes are adopted. Ms. Hur, please call the roll for a vote.
Juan Armenta,
Aye.
Eric Bergenson,
Aye.
Philip DeVizio,
Aye.
Vasco Dion Kidd,
Aye.
Edwin Perez, Bhavna Prakash, aye, Deborah Snow,
Go ahead.
Okay. Did we vote?
Aye. The motion is approved.
Michael Knotes, legal counsel. Really briefly, I need to interject. Our board member, Mr. Armenta, my understanding is that you have your video on, but we are not seeing it. And so we need to have that, we need to pause the meeting for a moment because there's a requirement. There we go. We shall continue. Good morning, Mr. Armenta.
Good morning. That was nothing I was doing. I just wanted to let you know.
No worries. It's good to see you.
Good to be seen.
To item number 4, public comments on items not on the agenda. Please note the board may not discuss or take any action on any matter raised during the public comment section that is not included on this agenda, except to decide whether to place the matter on the agenda for a future meeting. Are there any public comments from the room? Are there any public comments from WebEx?
Thank you, Mr. Board President. We still have no attendees, so I return the floor back to you.
Thank you so much. We're going out of order to address agenda item number 9, budget update by DCA budget analyst, and then we will follow with agenda item number 12, reconsideration of previously approved text by Shields and Dillon. Do we have our budget folks? I think they're on WebEx, right?
yes.
Okay, good.
Yes. Hello. Good morning. My name is Andrew Trudy, and I am an associate budget analyst with DCA Budget Office. I am here alongside Suzanne Falkers, budget manager. We want to thank the board and the executive staff for allowing us time to present the board's expenditure and revenue projections, as well as the fund condition statement. Please refer to agenda item 9 of the packet, which is the first page of the first page is the board's expenditure projections. We are presenting FM 11 expenditures with additional augmentation included in the budget. We are estimating $1.505 million in personnel services and about $2.245 million in OE&E expenses, for a total of about $3.7 million, which has created a surplus of about $96,000 or 2.54%. We are monitoring the fund and have been taking action to protect the board's solvency. The budget offices will continue to monitor these expenditures and report back to the board with monthly expenditure projection reports as future fiscal months close. Next page is the revenue projections. We have an end of year projection of $3.205 million against an estimated revenue of $3.013 million. We have no concerns about revenue, but will continue to monitor and update the board with monthly projection reports. Next page is the fund condition statement. The fund condition gives you a 5-year view of the board's fund, and I will speak to each section top to bottom, left to right. The first column includes prior year actuals, 23-24 actual beginning balance of about $4.2 million, with prior year adjustment of a negative $15,000. That gives us an adjusted beginning balance of about $4.2 million. Collected approximately $3 million in revenue and total expenditure of $3.3 million. That gives you a fund balance of about $3.92 million or 12.8 months in reserve. Next is the second column, current year, which is 24-25, which includes FM 11 projections, AG and enforcement augmentations, and is based on the 2025 Budget Act. The board has a beginning balance of about $3.92 million. The board projects an estimate of $3.205 million in revenue and $3.665 million in total expenditures. We currently have a fund balance of about $3.462 million, which gives you about 12.3 months in reserve. In the next 3 columns, we have the 25-26 budget year through 27-28 budget year plus 2 projections. These projections are based on the 2025 Budget Act, except for the income, which income from surplus money investments line item, which is formula driven. A few things to note of the board's fund condition. The fund condition is a snapshot in time and thus only a reflection of the data used in its creation. One of the main factors driving expenditure increases in future years is a result of personnel service adjustments. These include general salary increases, as well as employee compensation and retirement rate adjustments. The budget office includes an ongoing 3% increase to expenditures on the fund condition statement to account for these ongoing incremental adjustments. The fund condition does not include increased enforcement expenditures, which could create additional cost pressure to the board's fund in out years. The budget office will continue to work with the board on any future resource needs. Months in reserve will always go down in out years as we project revenues to remain constant and expenditures to increase by the 3% mentioned previously. And lastly, we would like to note to the board that any future legislation or unanticipated events could result in the board's need for additional resources, which would increase pressure on the fund. The budget office will continue to monitor the board's fund condition statement and keep the line of communication with the board's executive staff open for any future needs or expectations. That concludes our presentation, and we are happy to answer any questions. Thank you.
It's a presentation. I would just like to make a quick comment that it's good to see that our budget is in double digits and that we have 12.3 months in reserve. So really do appreciate that. Are there any comments or concerns from the board members? We seem to have a pretty healthy margin. All right. Are there any comments from the floor? Hearing none. Any comments from the WebEx participants, if there are any?
Thank you, Mr. Board President. We still have no attendees through WebEx, so I return the floor back to you.
Thank you so much. We will now move on with item number 12, Shields and Dillon.
Thank you. Thank you. Good morning, Christy Shields, Regulations Counsel for the board. Can you hear me?
Yes, we can.
Great. So after our meeting in November, we were reviewing the text and realizing the additional changes were probably going to need to be made. Those changes are summarized in your meeting materials memo beginning on page 2. In particular, your Sunset Bill, Assembly Bill 1501 would add and make additional changes to your Practice Act, which would remove the current remaining vestiges, if you will, of authority to regulate physician assistant training programs. And so these changes that we're bringing to you today would be contingent upon AB 1501 being enacted. And if it's enacted, we'd be able to proceed with the rulemaking to repeal the current physician assistant training program regulations, in particular, the $5 fee that you currently charge for reviewing postgraduate training programs for physician assistants. So I will turn it back over to the board members to see if you have any questions about these changes.
No, and I appreciate that. I think we often defer to the accreditor, right? So when these programs come through the pipeline, they're provisionally accredited and then they're considered approved by the board. So since we don't do a formal review or an autopsy of their sort of curriculum and standards, it would make sense that, you know, this would essentially be delegated and continue to be delegated to the accreditor.
Well, you would approve the crediting body, which you do have in regulation as CHIA. So this regulatory proposal would clean up that section of the
So really quick,
regulations
Christy,
as well.
who was the accreditor who's approved in regulation?
So if you look at, let me look at.
Because it should be the ARCPA.
Oh, I'm sorry, ARCPA. Sorry, ARCPA, and then CHIA is the fallback in case the ARCPA ceases to exist. So what we've done with the proposal, sorry, there's a little bit of feedback there. What we've done with the proposal is make it clear that ARCPA is the approved accrediting body by this board. And in the event, unlikely, but in the event that the ARCPA is somehow no longer exists, then you'd be recognizing the body, any body recognized by the Council for Higher Education Accreditation, which is CHIA. So it's sort of a fallback in case something were to happen to ARCPA, but we know that's probably unlikely. But we did want to put in a fallback position in case something happened and we had another accrediting body to rely on in the interim.
Sounds
So
great. Thank you.
that's kind of set forth more clearly on page 4 of the meeting materials memo.
Okay, thank you.
Thank you.
Are there any comments from the board? All right, hearing none. Are there any public comments from the floor? Seeing none, any comments from participants in WebEx, if we have some?
Thank you, Mr. Board President. We do have an attendee now. So if that attendee would like to comment on agenda item 12, please raise your hand. We'll give you a moment. All right, I'm not seeing a request for comments. So Mr. Board President, I return the floor back to you.
Thank you so much. So what would be the motion, just to adopt the current text, or how should we articulate that?
So the motion is option A under action requested. We would, if you have no changes, we would request you move option A, which is to rescind the motion passed at the board's November 2024 board meeting regarding this item. Approve the proposed regulatory text in attachment 1 and direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. If the board does not receive any objections or adverse recommendations specifically directed at the proposed action or the procedures followed by the board in proposing or adopting this action, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing if requested. If no objections or adverse recommendations are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations at 16 CCR sections 1399.506, 1399.507, 1399.511, 1399.530, 1399.535, 1399.536, 1399.538, 1399.539, 1399.546, and 1399.556 as noticed.
So moved.
Second.
So do we have a second? Perfect. Thank you so much. Thank you, Christy Shields and Ms. Dillon. We appreciate that. And then Ms. Dillon, you're going to stay up for the president's report because we're going to be doing AB 1501 right after.
Perfect.
Thank you. Public comment? Any public comment from WebEx?
Thank you, Mr. Board President. If any member of the public would like to comment, please raise your hand. We'll give you a moment. All right, I see no requests for comment. Mr. Board President, I return the floor back to you.
Thank you so much. Ms. Hurd, will you please call roll?
Juan Armenta. Juan Armenta.
He's
I'm sorry, it's defaulting to unmute for some reason, so aye.
Eric Bergensen.
Aye.
Philip DeVizio.
Aye.
Diego Insunza.
Aye.
Vasco Diankhe.
Aye.
Edwin Perez.
Aye.
Bhavna Prakash. Aye. Deborah Snow.
Aye.
All right, and the motion is adopted. Thank you. All right, agenda item number 5, President's Report. I want to thank Vice President Armenta and Executive Director Rosanna Kahn for their partnership on the Executive Committee and the PAB. I am pleased to share that AB 1501, the Physician Assistant Board's Sunset Review Bill, now includes a key amendment to modernize California's outdated supervision ratios, raising the physician and surgeon PA ratio from 1:4 to 1:8. This is a long overdue update as the current 1:4 ratio has remained unchanged since 2008. The bill also proposes to extend the board's operation until January 1st of 2030. In addition, all of the board's proposed amendments related to fee increases were included in the bill. As president of the Physician Assistant Board, I provided testimony before the joint hearing of the Senate Business, Professions, and Economic Development Committee on March 24 and again on June 30th regarding our Sunset Review Bill. My testimony included answering legislators' questions about PA supervision ratios. During the Sunset hearing, I responded to questions from Assemblymember Macedo about expanding PA practice in the Central Valley, a region struggling with limited access to care. I explained that revisiting the PA supervision ratio is one of the most practical ways to expand the PA workforce reach. I noted that California has already adopted a 1:8 ratio under AB 1070 for home health settings, but the law does not apply to PAs who provide direct patient care or prescribe medication, despite the fact that 95% of PAs nationwide prescribe. Expanding to 1:8 ratio across all PA practice settings would create consistency and better reflect modern clinical realities. It would also be a critical step toward reducing regulatory barriers and improving access to care, particularly in underserved regions. As a reminder, the PAB held comprehensive discussions about PA ratios prior to the hearings. The PAB remains committed to working collaboratively with the California legislature and key stakeholders to ensure that any changes align with current clinical practices. A special thank you to former board president Sonia Early for her outstanding dyad partnership on this initiative and to our board members. I also would like to thank CAPA leadership and members for providing public comments in support of our bill. In addition, Business and Professions Code 3502.3 was added to our bill. The legislature has expressed its intent to explore how physician assistant practice agreements are structured and implemented in California, particularly in comparison to other states. This review aims to evaluate whether such agreements support or hinder patient care, workforce efficiency, and appropriate regulatory oversight. The process is intended to be collaborative, involving input from relevant stakeholders across the healthcare system. Importantly, this provision does not require the physician assistant board board to lead or conduct the review, nor does it assign any new responsibilities, mandates, or workload to the board. The statute clearly states that the board may participate only as appropriate and solely through its existing authority and responsibilities. It is important to note that this code section does not preclude the board from initiating the review of practice agreements and reporting its findings to the legislature. Lastly, during the sunset hearing, the legislature expressed appreciation for the board's efforts in fulfilling its public protection mandate and commended the work of the PA profession in California. I will be establishing a practice agreement review committee, and I'll have more to say about that during our next board meeting in November. This will conclude my report. Are there any comments from the board members?
Yes, I do, if I may.
Yes.
Thank you. So for the new board members, maybe they weren't here for this, of course, but and some of you older ones may recall that we had a significant debate at the board about our participation in advocating for a change in ratios. And ultimately, the motion to have us step in that direction failed. And I think that was wise. I think letting us perform our public oversight duty is important, as opposed to expressing policy that governs PAs. That is appropriately left with the legislature. So I'm very pleased to see that the legislature took this under advisement and they made the decision to change ratios if needed. I think that's where it belongs and keeps us in our lane, so to speak. So that was an excellent result. I no doubt, Vasco, that your testimony helped push in that direction upon questioning from the assembly members. So that is good news indeed. And the exercise of discretion and policy, I think, was appropriately placed before the legislature for them to act and not us.
Thank you, Mr. Armenta, and I would underscore and agree with every one of your comments, eloquently put as always, and I'm grateful to the legislature for making this change. Are there any other comments from the board members? Are there any comments from the floor? Are there any comments from WebEx participants?
Thank you, Mr. Board President. If any member of the public would like to comment on this agenda item, please raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no request for comment. Mr. Board President, I return the floor back to you.
All right, Ms. Jasmine. So now we have our bill, AB 1501, which is a fantastic sunset bill, and I'm excited about it. Would you like to, I know that prior meeting, we took a wait and watch because it was a shell of a bill. So now it's been filled in with some language. So would you like to brief the board on what's in the bill? And then we can take a support position on that bill if that's where the board members want to go.
Thank you. So as discussed in the previous agenda item number 12 by Ms. Shields, the bill does include necessary updates to reflect that the board does not approve PA training programs. And then as discussed by the board president, the bill would increase the number of PAs whom a physician and surgeon may supervise at any one time to 8. And in addition to that, the bill would instead establish a $60 application fee, a $250 initial license fee, and a $300 biennial license renewal fee. The bill would authorize the board to increase the application fee to not more than $80, the initial license fee to not more than $500, and the biennial license renewal fee to not more than $500. And under existing law, a PA license expires at 12 midnight of the last day of the birth month of the licensee during the second year of a 2-year term if not renewed. Existing law requires a licensee to renew a license to apply for renewal on a form provided by the board as specified. This bill would instead require that the above described renewal applications be made on an electronic form or other form provided by the board. The bill would require an application form to contain a legal verification by the applicant certifying under penalty of perjury that the information provided by the applicant is true and correct. And then in addition to that, as Dr. Kidd, our board president, described, it does add Business and Professions Code 3502.35, which states the legislature's intent to investigate the practice agreements across the country. And that concludes the amendments, and the staff does recommend that the board take a support position on this bill.
Are there any comments from the board members?
Just for members of the public, to item 15, and we're just taking this item out of order, and we'll return to this item later.
Any comments from WebEx?
Thank you, Mr. Board President. If any member of the public would like to comment, please raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no raised hands. So, Mr. Board President, I return the floor back to you.
All right, I would like to entertain a motion to support our sunset review bill. Is there a motion?
I will go ahead and make that motion, Mr. Board President.
Okay, and then do we have a second? Thank you, Debbie. So it looks like so now we're taking a support position, right, on the bill. So moved or motion adopted.
Yeah, that would be my motion, is to take a support position.
Thank you so much. So now we will move on to, oh, yes, thank you. Yeah. Thank you. Any comments from the room? All right. Any public comment from WebEx?
Thank you, Mr. Board President. If any member of the public would like to comment, please raise your hand. We'll give you a moment. All right, I see no raised hands. Mr. Board President, I return the floor back to you.
Thank you so much. Ms. Will you please call roll?
Juan Armenta,
Aye.
Eric Bergensen,
Aye.
Philip DeVizio,
Aye.
Diego Insunza,
Aye.
Vasco Diankid,
Aye.
Edwin Perez,
Aye.
Bhavna Prakash. Aye. Deborah Snow.
Aye.
Motion is adopted. Thank you.
Can I make a comment, Mr. Board President?
Yes, sir.
I just wanted to congratulate the staff on this. You know, this getting to this sunset bill. As long as I've been on the board, it's been in the works. So getting to it is monumental. So I want to make sure that Rosanna congratulates her entire staff, and congratulations to Rosanna as well.
Yep, absolutely. This would not have been a success without them. Moving on to agenda item number 6, Executive Officer's Report. Ms. Khan.
Good morning, everyone. I will start off with personnel. The board is fully staffed with 11 authorized positions and no current vacancies. The next item is annual report. At the conclusion of fiscal year 2024-25, staff began preparing the board's annual report. The legislative mandated report informs the legislature, governor's office, agency, and the public of the board's accomplishments and activities over the past year. The narrative portion of the report was submitted to the Department of Consumer Affairs, DCA, on July 25, 2025. The annual report includes updates on legislation and regulations, licensing and enforcement statistics, staffing, board membership, fee structures, continuing education requirements, and other program-related information. The report is currently undergoing DCA's review and approval process prior to final publication. Lastly, outreach. On April 29th, board staff participated in the 2025 Kaiser Northern California PA Symposium, delivering a virtual presentation focused on the board's enforcement process. The presentation provided an overview of the complaint intake, investigation, and disciplinary procedures, helping attendees better understand how the board upholds its public protection mandate. The event brought together practicing PAs from across the Kaiser system to discuss clinical practice, professional responsibilities, and regulatory expectations. Board staff also addressed common enforcement trends and clarified licensee obligations when under investigation. Engaging with licensees in this setting supports transparency and fosters a strong understanding of the board's role in maintaining professional standards. I would like to thank Phil for allowing us this platform and for board staff to present. So thank you. That concludes my report.
Thank you so much, Ms. Khan. And thank you, Phil, for allowing for the opportunity. Are there any public comments from the floor? Hearing none, are there any public comments from WebEx?
Thank you, Mr. Board President. If any member of the public would like to comment, please raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment. Mr. Board President, I return the floor back to you.
Thank you so much. So we'll move on to agenda item number 7, board activity reports. We'll start with licensing. Ms. Caldwell.
Good morning. I'm Jennifer Jimenez, the licensing analyst, and I will be providing the licensing activity report today. The license population by type. This report breaks down the different types of licenses that we have and the statuses. The board has 2 types of licenses, the full regular PA license and the temporary PA license. As of July 29, 2025, the board has a total of 28,520 licensees, of which 19,410 are current and 3 are temporary. These are individuals that can practice medicine. The summary of licensing activity between April 1st and June 30th of 2025, the board received 537 regular and 3 temporary applications. During this quarter, 435 regular PA licenses and 2 temporary PA licenses were issued, and 2,191 individuals renewed their license. Pending application workload report. This report gives an idea of how many applications are in the system and where they are at in the process. The desk gauge reports is the number of days that the application has been assigned to a staff member, and the application desk age reports the number of days of the submission since the application of the submission of the application and the application fees. At the time of this report, there were 435 pending applications, 433 regular and 2 temporary. The difference in the color pie should not cause any concern. The color red shows 91 plus days. It means that the application has been reviewed, but there's just pending items to issue the license, such as like PANT scores or verifications. The licensing performance measures. The board has an internal target goal of completing the initial review of applications within 30 days of receiving the application and payment. During this quarter, the board processing times for complete applications is 25 days, which means the initial review of the application is complete and ready for licensure. The incomplete applications is 71 days, which means that there are still deficiencies. In our last meeting, Member Armenta requested data comparing California's PA's growth to other large states. While the board does not maintain such data, we obtain the information from the NCCPA. Please note the data only reflects PAs who are nationally certified. It does not include PAs who have not recertified. As NCCPA's recertification is not a condition for licensees to renew in California. Page 9 of the NCCPA report shows the top 5 ranked states of the number of PAs. This concludes the licensing activity report. Is there any questions?
And that was a good call out. Thank you so much for your presentation, right? Because the data that NCCPA collects is on certified PAs. So if you look at the data for California as an example, I think it's somewhere around 14,000 certified PAs, but we have, I think, over 19,000 licensees if you look at our own internal data. So there's a big disparity between certified PAs and non-certified PAs. And just for folks here on the board, and all of us know that are licensees, is that you have to obtain certification before you can obtain licensure. But relicensing does not require certification, but it could certainly impact your ability to bill if you're not certified. So just kind of keep that in mind. And the other thing I want to just mention, I think briefly, is the red bar where it does say sort of, preemptively, we accept folks to call in and say, yes, we want to apply for the license, but they're missing their PANT scores or they're missing some documentation. Does that increase the workload of the board to kind of give people sort of an early start into the process, or would it be better to have them submit the entire bundled package so that you're not getting these sort of piecemeal documents coming in that you're then now having to reconfigure their application? Wanted to get some thoughts on that.
Well, we allow 30 days to review the application, so that gives them time to submit everything. I don't think it creates more of a workload.
Okay.
We kind of just get things and then cross them off and get them going on their way.
Yeah. If that does become an issue as more and more PA programs come to fruition in the state of California, let us know. We can certainly revisit that.
Sure.
Thank you so much for your presentation. And are there any comments or questions from the board members? Any comments from the floor? Any comments from WebEx?
Thank you, Mr. Board President. If any member of the public would like to comment on this agenda item, please raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment. Mr. Board President, I return the floor back to you.
Thank you so much for your presentation.
Thank you.
Appreciate it. We have complaints. Good morning.
Good morning. Good morning, board, and the staff as well. My name is Linda Serrano, and I will be providing you a section on the enforcement activity report in regards to the complaints for the fourth quarter. We will be focusing on the fourth quarter, which is from April 1st, 2025 through June 30th, 2025. And as you can see, we have also provided the stats from the previous year. This report will also show how we are trending this fiscal year compared to last fiscal year. So as far as the complaints and volume, for the fourth quarter, we received 202. And for year to date, that's 647. For convictions and arrest, we received for the fourth quarter 17 and year to date 52. For a total of complaints received for the fourth quarter is 219 and year to date is 699. The average intake for days is 6 days. We have 0 complaints that are pending at intake. As far as complaints and investigations, complaints that were referred for investigation for the fourth quarter were 41 and year to date were 142. Complaints and investigations that were closed for the fourth quarter, 213, and year-to-date, 762. The complaints that are pending at desk analysts is 319, and that's current as year-to-date, 319. Investigations that are pending at the field are for the fourth quarter, 81, and year-to-date right now is 81. And then the average age of pending at investigations is about 143 days. And investigations that are over 8 months old, we have about 20. And then if we've also provided you a chart, and the chart is on the complaints that we have received by type and source. And that concludes my report.
Thank you so much, Ms. Serrano. Great. Appreciate that. Quick question. So are there redundant complaints? So as we look at the data, there could be sort of an inflation there, right? Because a lot of people, in a family can, if there was some sort of concern, multiple people can file a complaint, right, for a particular scenario, which could really inflate the data. I was wondering if you could sort of speak to that, because it's very hard to, we look at the numbers and we say, oh, that there might be a slight increase, but part of that could be related to inflation of sort of the complaints. Could you talk about that?
Yes. So regarding redundant complaints, we do receive redundant complaints. those are closed as redundant. But however, we have been receiving a lot more complaints that are coming from other state agencies, referrals, or they open up cases on PAs and they refer them to us. So I've seen a lot more cases come in where I guess more the consumers are complaining. And as far as redundants, I do see them,
Okay.
but they're not as many as the new complaints that are coming in that are not redundant.
And so that brings up my next question, which is, do we keep track of the percentage of redundant complaints that come in?
Yes, with the report.
Yeah.
We run reports, we could run them by type and source, and I'll let you know how many came in as redundant.
Yeah. And then out of the ones that do come in, would you say a fair amount actually get closed without enforcement action?
And are you referring to redundant ones?
Yes.
Okay. If they are redundant, that means there's another case already opened.
Yeah.
So that means we close the one that's redundant.
Okay.
There's no need to.
Okay.
Yeah.
Just to make
Maybe
sure
that'll
that.
work.
Yeah, exactly. All right, I'll hand it over to the board members. Any
I
concerns?
just wanted to add, I feel like another reason why we're receiving more complaints is people now know the PA board. We were,
Oh, okay.
medical board used to process our enforcement, take care of that. Now we're in-house. And we are doing more outreach. So
Okay.
that's another reason.
Thank you so much. Appreciate the clarification on that. Any additional questions from the board?
Yes, please.
Yes.
So, yeah, I don't necessarily, just a comment, I don't necessarily view the increase of complaints received as a bad thing. I think that's actually might be kind of a good thing, as Rosanna, that's kind of asked about that. As Rosanna points out, our visibility, I think, is getting better. So I think that may be a good thing. But what I am impressed about most is the average age of pending investigation has dramatically fallen. I was wondering if you could speak to what it is we are doing correctly that has caused that.
I would like to thank Linda Serrano. Now we have two staff members in the complaint unit. It was all Armando Melendez, when we first assumed all those responsibilities in-house. Now we have two staff members. And Mr. Melendez is now our special investigator in-house. By extension, he also assists Linda Serrano with desk investigations too. But Linda has come in and really, really cleaned it up. And, and we have our own subject matter expert in-house who processes everything now. So, yep. And we're in the process of making their positions permanent, so.
We're all supportive of that.
Yeah. I was hoping to hear good news like that, so thank you. I appreciate that. That is a significant drop in numbers, so good job, teamwork.
Debbie, you have a comment?
I have one question. Is there a sense of what area the increase is in? For example, is it substance abuse? Is it negligence, or maybe that's too specific?
If you look at the second chart, it's complaints by type and source.
Okay.
You'll see more of the gross negligence and incompetence.
Okay, thank you. And great job.
Yeah. Thank you, Ms. Serrano. We appreciate that. Thank you so much. Oh, I'm sorry, Dr. Sun.
One last comment, actually. I think in looking at absolute numbers, it may be misleading because if you have increased number of practicing PAs.
Absolutely.
So rather than looking at absolute numbers,
Right.
if you looked at it ratio-wise, it may have fallen.
100%. Yes, exactly. Yeah, that's a great point. Yep. And I think maybe if we can do that for, say, the next board meeting would be helpful.
Okay.
Right, because there could have been a precipitous decline,
Okay.
but we're not picking that up based on the data you're presenting.
Okay. Will do.
Great point, Dr. Sy.
Any
All
other
right.
questions?
No questions. Thank you so much. Discipline, Ms. LaFleur.
Good morning, everyone. This morning, I'll be presenting the board activity for the discipline for the fourth quarter and for the fiscal year, which is July 1, 2024 through June 30th of 2025. I'll start off with the suspensions. There were none in the fourth quarter, but overall, for year to date, there was one. For the cease practice order, there was one issued in the fourth quarter, and overall, there were two in this fiscal year. The interim suspension order, there were none for the fourth quarter, but overall, there was one. For the Penal Code Section 23, there was one issued this quarter, the fourth quarter, and then overall, there were three. For the Office of the Attorney General, transmittal, there were 7 cases initiated this quarter. Overall, for the fiscal year, there were 39, which was an increase. For the cases pending at the AG's office, there's 42. And for the average age of pending cases for the fourth quarter, it's 400, which is a decrease from last fiscal year. And for the formal actions filed, withdrawn, and dismissed, there was 5 accusations filed in the fourth quarter, and for the whole fiscal year, there were 20. For the accusation and petition to revoke probations that were filed, there were none filed this quarter, but overall for the fiscal year, there was one. And for the accusation withdrawn and dismissed, there were none this quarter, but there were 2 overall for the fiscal year. And then the petition to compel physical and psychiatric exam, there was one this quarter with an overall of 2 for the fiscal year. The next one is the administrative outcomes and final order. There were 2 probationary licenses issued this quarter, which is an overall 2 for the fiscal year. There were 2 licenses placed on probation. Overall for the fiscal year, there were 8. For the public approval, there was 1 issued this quarter with an overall of 7 through the fiscal year. There were 4 revocations for the fourth quarter with an overall of 8 total. For the fourth quarter, there was 1 license that was surrendered, but the overall is 3. And the petition for reinstatement that was denied, there was none for this quarter, but overall there were 2 for the fiscal year. And for the petition for termination of probation denied, there was 1 for the fiscal year, none for the fourth quarter. For the citation and fine, there were 29 issued for the fourth quarter, which overall for the fiscal year, there's 80, which shows an increase. There were none withdrawn in the fourth quarter, but overall for the fiscal year, there were a total of 7. And for closed and resolved, there were 15 in the fourth quarter, with a total of 40 for the whole fiscal year. There for the fourth quarter are 17 pending. Overall for the fiscal year, it's 46. The fines issued for the fourth quarter was $10,750. The overall amount is $29,750, which is an increase. The fines that were withdrawn in the fourth quarter was $1,250. Total for the fiscal year is $4,000. And for the fines received for the fourth quarter is $3,750. And the total fiscal year is $15,750. Does anybody have any questions?
Thank you, Ms. LaForte. That was fantastic. Any questions from the board members? Any questions from the floor? Hearing none, any questions from WebEx?
Thank you, Mr. Board President. If any member of the public would like to comment on this agenda item, please raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no request for comment. Mr. President, I return the floor back to you.
Thank you again, Ms. LaForte. We appreciate that. And we will now have probation and diversion. Ms. Gerard. Good morning.
Good morning, sir. Good morning, board. Good to see you, Mr. Armenta. So for this quarter, we had 1 license cancel. We had 4 licensees enter probation. We had 1 revocation. And we had 2 successfully complete probation. And you can see some of the people that no longer have a license, we're told, and my boss likes to see that. They're not practicing here. And so we ended out the quarter with 38 probationers.
Thank you so much.
Yes, sir.
Are there any comments from board members? Hearing none. Any comments from the floor? And are there any comments from WebEx participants?
Thank you, Mr. Board President. If any member of the public would like to comment on this agenda item, please raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment. Mr. Board President, I return the floor back to you.
Thank you so much. And thank you, Ms. Gerard. Appreciate it.
Thank you, sir.
And we are for agenda item number 8, Department of Consumer Affairs, Director's Update.
It's the diversion.
Sir, I was going to one.
I'm so sorry. Let me back up. Let's go to diversion.
That was
I got ahead of myself there.
We just had one more person enter diversion, so we end up with 6 people in our diversion program.
Is that it?
Yes.
Thank you so much, Ms. Gerard. Are there any comments from the board regarding the diversion report? Any comments from the floor? Madam Moderator, any comments from WebEx?
Thank you, Mr. Board President. If any member of the public would like to comment on this agenda item, please raise your hand. We'll give you a moment. All right, I see no requests for comment. Mr. Board President, I return the floor back to you.
Thank you. Let's try this again. Thank you, Ms. Gerard.
Sir.
All right, moving on to agenda item number 8, Department of Consumer Affairs Director's Update, DCA staff.
So good morning, everyone. My name is Arthur Babakanyan. I'm from the California Department of Consumer Affairs, and I want to just thank you.
Heather, sorry, is your mic on?
Yeah. It's good. Am I on? Yeah. I just want to speak a little closer to the mic. Okay. Sorry.
Yeah.
So I have a couple of updates from the Department of Consumer Affairs to share with you all. Starting off with the governor's reorganization plan. In January, Governor Newsom released his proposed 2025-26 state budget, which included a proposal to split DCA's oversight agency, the Business Consumer Services and Housing Agency, into 2 state agencies, the California Housing and Homelessness Agency and the Business and Consumer Services Agency. After public hearings and review by the Little Hoover Commission and the legislature, I am pleased to share that the governor's reorganization plan was enacted on July 5th. Again, the new Business and Consumer Services Agency will be responsible for consumer affairs, licensing and enforcement, and the Department of Consumer Affairs would be among the 8 departments in this new agency. The 2 new agencies will be officially become operative on July 1st, 2026. DCA is participating in multiple agency work groups on the logistics required to transition to the new agency and will continue to keep board and bureau leadership apprised throughout the year ahead. And then regarding hybrid telework transition, on March 3rd, 2025, Governor Newsom issued an executive order requiring all state agencies and departments to update their hybrid telework policies for employees and increase from 2 to 4 days in office per week beginning July 1st, 2025. At the end of June, agreements with several labor unions representing employees with the Department of Consumer Affairs were released, delaying the 4-day in-office requirement by 1 year for most employees. As always, we appreciate staff's flexibility as the situation evolved. And moving on to travel updates. On June 9th, 2025, the Department of Finance issued guidance for out-of-state travel in the upcoming fiscal year. Travel outside of California will be limited to essential travel that is required to conduct state business, meaning requests should only be made for mission-critical needs. DCA distributed a memo to all board and bureaus on June 16, 2025, detailing the criteria for mission-critical travel, including but not limited to enforcement actions, revenue collection, statutory requirements, auditing, and litigation. Additionally, all requests must be provided to DCA Budget Office 8 weeks in advance to allow for review by DCA, agency, and the Governor's Office. If there are any questions, please contact your assigned budget analyst at DCA. We would also like to remind board members and staff of our collective responsibility to work to minimize the cost to the state through responsible travel planning and scheduling. To best serve the public, it is incumbent upon all of us to ensure that we are being fiscally prudent in our decisions, especially when traveling for board business. DCA is reminding members and staff to evaluate if a rental car is always necessary versus ride-sharing services. Carpooling is also highly encouraged when renting vehicles. We know that there may be new travel costs board members are experiencing as well, such as baggage charges. So please keep receipts to ensure that you can be reimbursed. If you have any questions, please reach out to member relations so we may assist you. Okay. And then finally, the annual report. This is one of DCA's biggest projects. Staff work on this report throughout the year, gathering information and statistical data in order to compile a comprehensive report about the department's actions to submit to the legislature. On behalf of the director, thank you to board staff for your efforts and contribution. Published to the DCA website this summer, the annual report has a wealth of information and memorializes all the great work done by so many throughout the department. DCA encourages board members to take time to review it and use it as a resource. And that will be concluding my DCA updates. And if you guys have any questions, I'm willing to answer.
Thank you so much for that report. Are there any questions from board members? Hearing none, are there any questions from the floor? Hearing none, any comments from WebEx participants?
Thank you, Mr. Board President. If any member of the public would like to make a comment on this agenda item, please raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no request for comment. Mr. Board President, I return the floor back to you.
Thank you so much, and thank you for your presentation. Appreciate it. Many of you know we skipped item number 9 because we front-loaded that in the agenda. So now we are moving on to agenda item number 10, Report on Medical Board of California Activities. Dr. Tsai.
Thank you, Mr. President. Good morning to the rest of the board members. The Medical Board of California met on May 15th, 2025. We had a short meeting. The main focus of the meeting was basically on legislation, and several of them are what was presented in your board packet today, some overlapping stuff, so I won't go over it. The main focus was pushing through Physician Wellness Program AB 408, which is sponsored by Representative Berman. California, as you are aware, does not have a diversion program for its physicians, and I think time has changed, and the shift now is promoting wellness among physicians, and so we're watching that particular legislation intently. Otherwise, as the summer rolls on, a lot of our board members have turned over, and the governor has appointed 3 new members to our medical board. Mr. Arkatov, who's an attorney in LA, Dr. Trinidad Solis, who's a family practice doctor from Fresno, and Gerald Holbert, who's a ER doc from San Diego. They joined our medical board. And lastly, our next meeting is actually next week in San Diego. So I'll have more to report at the next meeting.
Thank you so much, Dr. Tsai. Are there any questions from board members regarding Dr. Tsai's report? Are there any comments from the floor? Any comments from WebEx participants?
Thank you, Mr. Board President. If any member of the public would like to comment on agenda item 10, please raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no request for comment. Mr. Board President, I return the floor back to you.
Thank you so much. And again, Dr. Sai, thank you for the report. Moving on to agenda item number 11, overview of the enforcement process, Lafort and Serrano.
Good morning again.
Good morning.
We will be going over the complaint process, and it's an overview of what we do in the enforcement, the complaint. I'll be doing the complaint. She'll be doing regarding to discipline. So with the complaint process, we receive the complaints. Usually our complaints come from, obviously, the consumers. They could come from other state agencies. They could come from health workers, law enforcement, pharmacies, other federal agencies as well. When we receive complaints, we're looking to see if they're within our jurisdiction. So that way to see if we're going to process them. And if they're not within our jurisdiction, we refer them to the appropriate agencies. We always, if they are within our jurisdiction, we request, for medical records, medical release forms. We start the process. The consumer is given a letter of acknowledgement once their complaint comes in, and with the brochure that gives them information on how the process works. So they get some information up front. And then once it goes through our whole process of, desk analyst work, we also determine if it needs to go to our investigations. Some complaints immediately need to go to our investigations. They don't get processed. They just go directly to investigations. And then once it goes through the desk, if it does not need to go to investigations, we collect the medical records, and then a medical consultant will review them to determine if there was a violation. And if there was, that's when we determine if it goes to our investigations office. They process it over there. Then they make another determination if disciplinary action is merited. And that's when Christina comes into play doing the discipline aspect of it.
Okay, so if the investigation finds evidence that the physician assistant has violated the Physician Assistant Practice Act and the Medical Practice Act, and the violations warrant disciplinary action, the case is forwarded to the Attorney General's office to prepare an accusation. An accusation is a legal document that lists the charges and/or the sections of law alleged to have been violated and served on the licensee. The accusation is served to the licensee's address of record. The physician assistant is entitled to dispute the charges at an administrative hearing. The request for a hearing must be received within 15 days after the accusation is served, pursuant to Government Code Section 11506. The request for a hearing may be made by delivering, mailing, or emailing a notice of events to both the Deputy Attorney General and the Physician Assistant Board. The Deputy Attorney General's name, address, and telephone number appears on the front page of the accusation. The notice to the Physician Assistant Board should be directed to the enforcement program by email or mail. If a notice of offense is not received, the physician assistant will be deemed to have waived the right to a hearing, and the board may proceed to act on the accusation without a hearing and may take action as provided by law. The physician assistant may but need not be represented by counsel at any or all stages of these proceedings. The hearing is an administrative proceeding that closely resembles a court trial and is presided over by an administrative law judge. After the hearing, the administrative law judge writes a proposed decision. The proposed decision is then sent to board members for consideration, and if a stipulated agreement between physician assistant board and the licensee is reached prior to the hearing, then no hearing is necessary. The members make the final decision on disciplinary matters and can either adopt, modify, or reject the proposed decision or stipulated agreement or settlement, Another form of action the board can take because of a minor violation of the laws and regulations is an administrative citation order or an educational letter. The definitions for the actions that the board can take is on our website. And it's under the disciplinary actions tab. It gives you all the definitions. So that concludes my presentation. Does anyone have questions?
Thank you so much for that comprehensive presentation. Quick question for you. If there is a violation of the Physician Assistant Practice Act, does that automatically lead to a violation of the Medical Practice Act? Or can you have one and not the other?
Yeah, they kind of, because we look at, the violations are in both the Physician Assistant Practice Act, and there's two different ones. It all depends. And the minor violations is that what you mean, would lead to like an educational letter. And this all will stem from whatever the investigation concludes.
Okay.
But did that answer your question? I hope it did.
It does, to some degree. I think sometimes I always, like, if there is a violation of the Physician Assistant Practice Act that's legitimate, is there a one-to-one correlation that would lead to then a violation within that? Because our regulations are so closely tied.
They are, yes.
So I just want to know, so.
Yeah, Michael Knuts, legal counsel. I think that is, as a very general sort of 10,000-foot statement, I think that is true, that if there's something that we would subject you to discipline as a PA, that's probably going to subject you to discipline as well as a physician. What's helpful for you, however, is the provision that allows you to impose discipline based on the Medical Practice Act, because there may be some provisions in the Medical Practice Act that are not in the Physician Assistant Act. And some of the other boards that used to be medical board committees, that's the case. And it can be very helpful for you because you have those other options to pursue if appropriate, and need be.
So there's a code section that says any violation of this Practice Act is also a violation of the Medical Practice Act. Yeah.
I had a question regarding the complainant. You notify them at the beginning of the action. Do they receive any updates along the process?
Yes, they're notified when the case goes to the Deputy Attorney General's office. They're notified when an accusation is filed, and then they're notified of the final decision. So they are.
That's good to know.
Are there any other questions from board members?
I have a question. You mentioned complaints coming in from other states for PAs. What happens in that case when a judgment is reached by our board and the law judge, et cetera? Is that communicated back to the state that the complaint originally came from?
So I can answer that. What happens is we have the Federation of State Medical Boards, and if any of our licensees are licensed in other states and they take action, we received what's called a disciplinary alert from the Federation of State Medical Board. And from there, we would, get the documentation and determine if what that violation was would warrant violation here in California. And then the process, it's initiated.
Mm-hmm. Any additional questions or comments from board members? Okay. Any comments from the floor? Any comments from WebEx participants?
Thank you, Mr. Board President. If any member of the public would like to comment on agenda item 11, please raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment. Mr. Board President, I return the floor back to you.
Thank you so much. Are there additional comments?
I do have one. It may be more of a legal question. If a complaint is made to like a hospital or a medical professional, are they required to send the complaint to our board? Or is that like in the law somewhere?
I wonder, are you referring to like an 805 report?
There are certain requirements that relate to complaints being filed at medical facilities.
Mm-hmm.
We would need I think a whole agenda item to go through all that for you. But there's certain things, malpractice settlements.
Thank you.
There's happy to talk to you about that anytime, though, board member.
Okay, yes, because this has been some time in the past with another board, but hospital ended up just like sending the practitioner, and this was a medical doctor, from hospital to hospital rather than reporting to the medical board. And again, this has been years ago, but it made the news. Okay, thank you.
Thank you. Are there any additional comments from board members? All right, well, thank you both. Really appreciate the presentation. Thank you so much. We are moving expeditiously through the agenda. We will be taking a bio break, I promise, very soon. Just want to get to a couple more agenda items and then we'll take a quick break, if that's okay with everyone. So we are now skipping item number 12 because that was front loaded at the first part of the agenda. So we went through that. We're now moving on to agenda 13, which is regulations update on pending regulatory packages. Ms. Dillon. And just to remind the board members, we have already reviewed our AB 1501 sunset review bill, so that would not be a part of this agenda.
All right, good morning. I will be providing the update on pending regulatory packages. The first package is the license renewal and continuing medical education required. This regulation would clarify, interpret, and make specific all requirements for license renewal. And the board was seeking amendments to Business and Professions Code Section 3523 to address apparent authority issues with providing their renewal application online through Breeze. And the legislature has since included amendments to Business and Professions Code Section 3523 and AB 1501. And once the bill is chaptered, staff will continue to work on completing this package. The next package is titled Application Exam Scores, Addresses, and Records. The board adopted the proposed revised regulatory language to initiate the rulemaking process at the November 8th, 2024 board meeting. And the board was asked in agenda item 12 to review and adopt proposed revised regulatory language to continue the rulemaking process. And then the next package listed is retired status updates and return fingerprint requirement. The board voted to adopt the proposed regulatory language to initiate the rulemaking process at its April 21st, 2025 board meeting, and staff is working to submit initial documents for budget and legal review. The next package listed is titled Implement Uniform Standards Related to Substance Abusing Licensees and Update of Disciplinary Guidelines. Staff is working on the proposed language for board approval next calendar year. And then finally, the last package listed is titled Initial License Fee. And this package increases the initial licensing fee to $250. Agency approved this package on March 5th, 2025, and the notice was filed with the Office of Administrative Law for publication on March 21st, 2025 to initiate the 45-day public comment period, which ended on May 5th, 2025. No comments were received during the public comment period, and the final documents were sent to legal and agency for review. Once approved, the final documents were submitted to the Office of Administrative Law for final review on June 25th, 2025. And this package was filed with the Secretary of State on August 4th, 2025, and will become effective on October 1st, 2025. And that concludes my update.
Thank you so much, Ms. Dillon. Are there any questions from board members? Seeing none, are there any comments from the floor? Hearing none, are there any comments from WebEx?
Thank you, Mr. Board President. If any member of the public would like to comment, please raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment. Mr. Board President, I return the floor back to you.
Thank you so much. Thank you, Ms. Dillon. We appreciate your report. Thank you. After agenda item number 14, we're going to go ahead and take a break. So this agenda item is education, workforce development, but really it's been renamed. I think it's been renamed the Physician Assistant Training Advisory Committee, Workforce Development. So just to provide some information regarding this agenda item, there are currently 318 nationally accredited physician assistant training programs in the United States. Of those, 20 are located in California. I'm pleased to report that none of the California PA programs are on probation. Presently, there are 6 provisionally accredited programs and 4 developing programs in the state. Geographically, California PA programs are distributed as follows. 15 are in Southern California, 4 in the Bay Area, and 1 in Central Valley. During the last ARCPA accreditation cycle, there were no new PA programs in California approved for provisional accreditation, according to the last Physician Assistant Education Association report. The current annual enrollment capacity across all 20 California PA programs is nearly 1,000 students, averaging 48 students per program. With planned cohort expansions, the total annual capacity is projected to remain slightly over 1,000 enrollees. This concludes my report. Are there any questions from board members? Any questions from the floor? Any questions from WebEx?
Thank you, Mr. Board President. If any member of the public would like to comment, please raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no request for comment. Mr. Board President, I return the floor back to you.
Thank you so much. At this time, we will be in recess for 15 minutes. Thank you. 10 o'clock, let's reconvene. And we are right on time on the agenda, so I'm pretty excited about that. Thank everyone for being participatory in this process. We are now on agenda. Oh, I'm sorry. We should call roll to make sure folks are here. Ms. Hurd, would you please call roll?
Sorry. Juan Armenta,
Yes, present. Thank you.
Eric Bergensen,
Present.
Philip DeVizio,
Present.
Diego Insunza,
Present.
Vasco Diankit,
Present.
Edwin Perez,
Present.
Bhavna Prakash, present, Deborah Snow, here, Viling Sai.
Here.
Okay, that concludes the roll.
Thank you, Ms. Hurd. Moving on to agenda item number 15, report by the legislative specialists and legislative update. Ms. Dillon. And it looks like we have a guest.
So we will be going through the bills a little out of order today. We will be discussing item 15C first, which is AB 489, Healthcare Professions, Deceptive Terms or Letters, Artificial Intelligence. So this bill was introduced on February 10th, 2025, and is located in the Senate Committee on Appropriations. This bill would make provisions of law that prohibit the use of specified terms, letters, or phrases to falsely indicate or imply possession of a license or certificate to practice a healthcare profession enforceable against an entity who develops or deploys artificial intelligence or generative artificial intelligence technology that uses one or more of those terms, letters, or phrases in its advertising or functionality. The bill would prohibit the use by AI or Gen AI technology of certain terms, letters, or phrases that indicate or imply that the advice or care reports, or assessments being provided through AI or Gen AI is being provided by a natural person with the appropriated healthcare license or certificate. And I have Lisa Morosky, lead staffer for AB 489 here as well to address any concerns or comments from the board.
Thank you so much, Ms. Dillon, and appreciate the board for taking the time to hear from us about this bill, and for Ms. Dillon for reaching out and discussing kind of the board concerns and questions that came up last time. So we've had some really productive conversations with a lot of different parties throughout the process, different boards, DCA, the AG's office, lots of stakeholders. So hopefully I can just briefly describe some of the conversations and things that have come out of that and give you a little more background to maybe address some of the concerns, and then happy to take any questions. As Ms. Dillon mentioned, my name is Lisa Morowski. I'm principal consultant to the Assembly Health Committee. working under our chair, Assemblymember Bonta, who's the author of AB 489. So, of course, we're all familiar with the rise of Gen AI. This bill is, we think, is a straightforward kind of common sense solution to a particularly like insidious aspect of this technology, and that is AI systems misrepresenting themselves as health professionals. So based on our conversations with Ms. Dillon, I believe the board shares kind of our concerns about the system's capabilities that can allow it to mimic health professionals. And really, without proper safeguards in place, we're really concerned about the danger this poses to consumers in healthcare settings and non-healthcare settings. So in researching this issue last fall, we were really dismayed to see, you know, kind of consumer-facing websites that were posting or showing chatbots that were representing themselves as health professionals, mental health professionals, using licensed titles and boasting that they had millions of chats with like actual people. You know, obviously we rely on our licensing laws to establish strict standards for, you know, qualifies you to say you're a licensed health professional. So we think that, you know, if we apply that to a person, the same thing should apply to an AI system. So the bill's not intended to expand or change kind of the existing title protections, but it is intended to simply clarify that those protections that are in state law that apply to people can equally be applied to AI systems. So it's intended to draw a bright line and say, you know, AI systems cannot represent themselves as health professionals, period. So really the heart of this, we hope and believe and expect that if this becomes law, that developers and deployers will make a good faith effort to comply with this law to kind of prevent this prohibited behavior from happening in the marketplace. So we're really looking at this bill primarily as a deterrent to promulgating that behavior. In the case that there are persistent bad actors in this space, we do also want to make clear that the state can, you know, hold the developer, the deployer of the technology accountable for making sure that the technology doesn't violate the title protections in the law. So we wish this wasn't necessary, but unfortunately, as we've seen, we have numerous examples even as we speak. Also in thinking about, and this may be like slightly more relevant to the physician assistant board, as we think about AI being adopted in the healthcare space, establishing transparency here is really critical so people know if they're talking to an AI or talking to a real person, a licensed person. We've got a lot of support for the bill. A lot of people are really concerned about this. So the bill is sponsored by SEIU California and the California Medical Association, supported by the Attorney General's Office, numerous boards within DCA, the Medical Board, Osteopathic Medical Board, Dental Board, Board of Psychology, Board of Behavioral Sciences. I hope I'm not forgetting anyone, but numerous health professional associations, like every specialty I can think of pretty much, and a lot of consumer organizations, and even the LA Chamber of Commerce wrote a letter in support. Just a lot of, you know, support across the board about just establishing this this precedent and rules of the road. So in thinking specifically about the board's kind of questions around the impact on enforcement and how this would be implemented. Of course, as I mentioned, we really think the deterrent effect is hopefully the most important piece of the bill, but we also have understand that, you know, it could take significant resources to go after, you know, big companies and sort of and that sort of thing. So we want to kind of assure you that, first of all, the board is not required by the legislation to take any particular enforcement action. Any kind of enforcement would still be within the discretion, priorities, resources available to the board. So that doesn't change anything there. We are really trying to kind of streamline, you know, if this does come up as an issue, we don't want to force, you know, your lawyers to go through and say, oh, well, can we this is an AI, not a person. Can we apply it? You know, we want to kind of streamline that and kind of do that analysis up front and say, yes, absolutely, it's prohibited. So we hope that could, you know, if in the case that you do have to take some kind of action, I think that that kind of pressure is generated by what's happening in the world, right, in the marketplace of people, you know, being bad actors and not necessarily by the bill, I guess. I would like to just briefly describe our conversations with the AG's office and what they've explained to us is how they would work, you know, if the board were to refer cases to the AG. We do think that, you know, although we want the boards to have authority to enforce their own title protections, this becomes a bigger consumer protection issue, probably affecting lots of different boards. And you know, it's probably less likely that there'll be one company or actor that's specifically saying physician assistant, you know, I'm a physician assistant versus an actor that is, you know, kind of making it available to represent all kinds of different health professionals like is happening right now. And at that level, you know, it's not a physician assistant board issue. It's a broader consumer protection issue. So the AG in particular has described to us how they could enforce the law. They have multiple remedies available. So they usually use the unfair competition law to enforce kind of prohibitions that exist. So the prohibitions in AB 489 would be sort of the underlying violation, and then they would use the unfair competition law to enforce using the remedies they have available, which are to sue in state court, issue civil penalties, seek civil injunctions. If the defendant has turned this prohibited behavior into profit, they have disgorgement capabilities to seek to address that. So those are some of the things that the AG can do. Again, we believe that boards would, you know, engage with the AG or DAs and as appropriate and refer to law enforcement. So hopefully that addresses some of the concerns specific to kind of the enforcement burden. And again, thank you so much for the time and the interest and being willing to engage on this bill, and happy to answer any questions.
Thank you so much. I appreciate the comprehensive discussion regarding AB 489. And I think from a board perspective, we took a watch position on this, I think, previously on this bill. You know, board members had, you know, of course, expressed concerns regarding the operational burden, which you addressed. So I appreciate that. But also the expense burden that could land on the board. And so I was wondering if maybe, part of that sort of expense, or maybe it ties there, maybe it doesn't, but what happens if you have an AI software that's foreign? Does this bill cover that? So just wanted a little bit more, if you could distill down a bit for us on those sort of kind of the expense sort of concerns that I'm sure not are just expressed with our board, but that other boards, and then sort of kind of foreign bad actors that potentially could end up needing a review. So I just wanted to get your thoughts on that.
Thanks for the question. And yeah, you know, there's a lot of kind of internal operational things that I probably can't speak to within the board and DCA, and how, you know, you all know better how you particularly approach these things and do your work. But I guess I would emphasize that if there is a software company that is a foreign actor or something that sort of exists in the world. And so what the bill is particularly doing is saying that, you know, providing the clear authority to go after that actor. And, you know, depending on, because all the board's title authorities are a little different, what they can do with that is a little different. So we were just trying to sort of create this, the authority to make it clear that you can approach, you know, whatever the situation is, there could be lots of different types of, I can't even imagine some of the things that are coming out of this Gen AI. But so really, I guess what I'd say about, I don't think it's the bill in particular that would create sort of a burden. I think the burden, if it exists, is probably created by the behavior in the marketplace that is concerning. So the board is just, the bill is just really trying to streamline that and to say, you do have the authority. And in that case, if it's a multinational corporation or whatever, I would think it would make sense to engage law enforcement at that point.
So thank you so much. I appreciate that. And it's also good to hear kind of a coalition of folks that are supporting this sort of bill. So that's also encouraging. I share a lot of concerns with the use of AI in the healthcare space. And certainly if you have bad actors, you want to have a mechanism for being able to deal with that. So I do appreciate the information. Is there a question?
Well, no, I just wanted to, I'm Michael Knotes, I'm the board's legal counsel. And what I wanted to just add on to the presentation is that the board doesn't have jurisdiction to pursue, like, say, a multinational corporation that's operating something more in the lines of what was described. But where this could be very helpful for the board is our primary enforcement duty relates to our licensees. And if we had a licensee who was using an AI and, sending their patients an AI link and saying, hey, why don't you chat with me on AI, but it's not really them. Then this could potentially help us go after individual practitioners that are inappropriately using AI. That's a much smaller, I don't think it's the main focus of the bill, but I don't see it requiring us to do anything different in terms of our enforcement duties that we have today.
Thank you for the clarification, and that was extremely helpful. Are there any other questions from board members? Yes.
Yeah, really, just more general. That it's a federal bill that they passed recently. Originally, it had a provision for a moratorium on regulation on AI. They removed it. But I don't know if you're familiar with whatever was in that provision. But, okay, because I was going to ask if they were somehow to restore it or bring it back, would that preclude the state, and more specifically, well, it will be the legislature, but would it preclude the legislature from enacting laws that, just like what we're, envisioning here, right? There's a moratorium. Is it like all encompassing?
It would really depend on the nature of the federal law. There is federal law is the supreme law of the land and will supersede state laws in certain situations. But frankly, I don't know enough about the situation to be able to answer that. We can certainly take a look if the bill passes.
I'd just like to thank you again for your presentation. It's excellent. Oh, sorry. And as a consumer protection agency, I would strongly support it. I can only speak for myself, but that's the paramount duty, and this sounds crucial with this becoming a problem. That's all I wanted to say. Thank you.
Thank you. Any other comments?
Just FYI, the medical board took a support position on this bill because a lot of times it's unintentional. If you're, writing to your doctor and the chat box comes up and it says Dr. Robot, fairly obvious, but some people may think this is a guy or a gal named Robot. And so they are unaware. By putting that Dr. Robot, it may mislead unintentionally as people thinking they're chatting with a live person. So we support it because we wanted to remove any sort of misleading labeling or titles that can mislead the consumer.
Thank you, Dr. Sai. I appreciate that comment as well, Ms. Snow as well. I would like to entertain a motion of support for this bill.
Before we get to it,
sorry, Mr. Armenta.
Thank you, no problem. I know I'm not in the room, so So I'm having trouble, and maybe our speaker can speak to this. I'm having a little trouble imagining scenarios. I think one was just mentioned by Dr. Sy, and I think Michael did too. But scenarios in which we would see a PA involved in this. I mean, the only one I can see readily is if they are some type of investor in a chat or rather an AI type interface, or as Dr. Sy points out, someplace where they're doing a telehealth and somehow there's a box that entertains it and the client gets there. I don't know what the motivations would be, but that would be another way I can see the vehicle. So where is the envisioned intersection of a PA's active participation in doing this? So that's part one. Now, secondly, I don't think it would cost us anything since we don't have jurisdiction on this. But I think, as Michael points out, just under a general negligence or a negligence point of view, if a PA is referring people to a AI for diagnosis or treatment recommendation or anything else, that's something we could certainly use under that principle. So I don't think it would cost us anything. So in that case, I would support. But I would like a comment from the speaker or anybody else as to where they see the intersection between AI and our duties to oversee PAs insofar as the PA is actively participating.
If I may make a comment. Good question. One of the things that I've seen in practice is the use of AI in medical documentation, where the institutions that I worked at, where we have the opportunity to use a chatbot to capture the documentation or the conversation that happens between a PA and the patient or whoever's in that room. Where this may lead into issues is if the PA is not able to go back and look at the documentation of the chart that has been prepared after the visit and realign all the notes that have been taken to make sure that the conversation is apt to what was discussed, or having a notation that lets the patient know or the consumer know that this conversation was recorded with the help of a chatbot or an AI tool. Because that is where I think where we may see it as a licensee coming up with certain documentation gaps, things that were not captured by the licensee per se, but more of a AI use of technology to document the encounter.
That's interesting. Okay. I didn't think of that. And I actually saw an example of that in the legal field where we had a counsel, and some of this made news in other cases, counsel use AI to create a legal pleading, an argument. And AI kind of tells you what you want to hear if you don't phrase the query properly. And it got the law completely wrong. If you went and read the cases, you say, no, these are all the exceptions that AI is talking about, and none of the exceptions are satisfied. So I can see that's an excellent point where somebody's capturing it. So that sounds though like, wouldn't it, Michael, if a PA did that, it would still fall under the general negligence type of enforcement, right?
Yeah, I really don't see this changing our enforcement analysis on these types of issues. I mean, it gives us another tool, but if we had a PA that was violating this, and again, I don't think this is primarily going to be used. I think the example even that I gave was probably a little bit far-fetched.
Yeah, okay.
Yeah, if I could just, one thing to add that, is sort of an emerging field, I think, in the use of, kind of as AI becomes more and more, Gen AI becomes more and more kind of human-like, it can be harder to tell who you're talking to, even like live conversation, even like live video feed now, you could really, if you don't have that expectation of transparency and the clear rules of the road that we're trying to establish. Like, we don't want a company to be able to just put up that it's, physician assistant Brown. This is what we're trying to get in front of too. I mean, we haven't, to my knowledge, we haven't seen that happen. That's a very scary thing. But we just want to be clear that yes, the law is already clear on title protection. It also applies to AI. That's kind of where I could see, hopefully not, but potentially, like if you're talking to a nurse or a care manager or, that we're very clear about. And this doesn't address everything. It's pretty narrow to title protection, but we think it's kind of the minimum first step to really establishing some clear rules.
Thank you so much. Oh, I'm sorry. Go ahead, Mr. Armenta.
Yeah, that's clarifying to me. Thank you. So it sounds like this bill really, if I get the meaning, is to clear the pathway for the AG to use the UCL more capably when he or she confronts these types of AI misadventures. Is that right?
Yeah, absolutely. In our conversations with the AG, at the AG's office, they have indicated that, it's a question of evidence. And if you make the law and what they're trying to collect the evidence to very clear, then they have that clarity that will assist in the analysis of whether they can, have a case and bring it under the UCL, as you mentioned.
Yeah, okay, that makes sense. So Mr. Board President, my comment would be that I agree with Member Snow that given that there's very difficult to envision how it would cost us any money, that if you're ready for motions, I would make the motion that we support this because
we have, Mr. Armenta, sorry to interrupt you. We have one more comment from a board member, so I want to make sure that we hear that comment first.
Thank you. I may be getting a bit far afield. I do understand the importance of this and support it in principle, but looking on the back end of patient care, when you're looking at discharge instructions and home care that is sometimes AI generated, that is separate after the fact, this bill looks like it denotes all communication to the patient. So will there be a requirement do you foresee a requirement on the back end where we need to say these discharge instructions were produced by an AI component or a bot at some point? Or is this only for the upfront kind of initial evaluation? Does that make sense?
Yeah, and so I think, so the bill, there's lots of different applications of AI, right, in the healthcare field and healthcare delivery, and this bill doesn't cover all of them. So it's really about the representation of, are you using a title protected term? And if you are, then you have to be a licensed professional. And so it doesn't, I see exactly where you're going. I don't think this bill particularly covers those types of situations because there's not like a misrepresentation. If it said it was generated by a particular physician assistant and that was an AI generated thing, then I guess that would come into play. But I think for the charting and documentation, it's kind of in a little different bucket.
So this is really focused on sort of protecting those professional titles.
Exactly.
So that would make sense to me. And just, I think, unless there's additional comments from board members, I think we should take a support position on this, and I would entertain a motion.
I'd second it.
All right. Are there any comments?
Okay, so I did, Michael Kenotes, legal counsel. We would need a motion to support. And are you making that motion?
Yeah, it's a motion to support.
Okay. As it came out, it didn't quite say that. And we've had a second. We can proceed, forgive me.
Should we do it again no, we're good? Okay, I just want to make sure. Okay. And so are there any public comments from the floor? Any public comments from WebEx?
Thank you, Mr. Board President. If any member of the public would like to comment, please raise your hand. We'll give you a moment. All right, I see no request for comment. Mr. Board President, I return the floor back to you.
Thank you so much. Ms. Hurd, would you call the roll, please?
Juan Armenta,
Aye.
Eric Bergensen,
Aye.
Philip DeVizio,
Aye.
Diego Insunza,
Aye.
Vasco Diankid,
Aye.
Edwin Perez,
Aye.
Bhavna Prakash. Aye. Deborah Snow.
Aye.
All right, the motion carries. We are in support of AB 489. Thank you so much.
Thank you very much.
All right, Ms. Dillon, the floor is yours.
All right, so we will be going backwards to item 15A, AB 447, emergency room patient prescriptions. So this bill was introduced on February 6, 2025, and is located in the Senate Committee on Appropriations. And this bill would authorize a prescriber to dispense an unused portion of a dangerous drug acquired by a hospital pharmacy to an emergency room patient upon discharge if certain conditions are satisfied, including that the dangerous drug is not a controlled substance and that dispensing the unused portion of the dangerous drug is required to continue treatment of the patient. And at the April 21st, 2025 board meeting, the board took a support position on this bill.
I don't see any sort of issues why we would not support this bill. Anyone in disagreement with that? All right, thank you, Ms. Dillon.
All right, moving on to item 15B, AB 479, criminal procedure vacator relief. This bill was introduced on February 10th, 2025, and is now considered dead. However, it is a 2-year bill, and it could be acted upon next year in January of 2026. So as of right now, there's no concerns with this bill, and if it is acted upon the next legislative year, then we can discuss this at the next meetings.
Sounds great, thank you.
And then moving forward to item 15D, AB 667, professions and vocations, license examinations and interpreters. This bill was introduced on February 14th, 2025, and is located in the Senate Committee on Appropriations. This bill would require certain boards under the jurisdiction of the Department of Consumer Affairs to permit an applicant who cannot read, speak, or write in English to use an interpreter to interpret the English written and oral portions of the license examination if the applicant meets all other requirements for licensure. However, an exemption was added to this bill for healing arts boards. So this ensures that the board is not required to provide the interpreter accommodations for the license examination. And at the April 21st, 2025 board meeting, the board took an oppose unless amended position.
All right, so I'll open it up to board members. You said there was a recent amendment that was added?
Yes,
to the bill?
which excludes all healing arts boards from the requirements of the bill.
So it doesn't really apply to us at all?
No, not anymore.
Yeah. So then at this, say we're still opposed, right? I mean, or do we take a position or not? I mean, there's nothing to take a position on because it doesn't apply to us.
Right, so I guess we could take a watch or remove our position.
Well, generally, so the board took an opposed unless amended position, and the bill was amended in the way that we desired, which makes us not, which makes the bill not apply to us. It may be appropriate then to change the bills, to make a motion to change the board's position to watch neutral.
Okay. Let's take a position to watch, if that's okay with board members. I don't think we need a vote on a watch position.
Well, you do, because currently your position is opposed unless amended.
Okay. Okay. Ms. Hurd, would you like to call roll, please?
So.
Oh, do we need to make a motion?
Mr. President's making a motion to change the position on the bill to watch.
Second, thank you. Ms. Hurd, would you like to take roll?
We need public comment.
First or after
the motion?
Oh, okay.
Public comment on.
Oh, there's your public comment. Okay.
Okay, hearing no public comment, I think we can proceed.
Okay. Ms. Hurd, can we call roll, please?
Juan Armenta,
Aye.
Eric Bergensen,
Aye.
Philip DeVizio,
Aye.
Diego Unzunza,
Aye.
Vasco Diankid,
Aye.
Edwin Perez,
Aye.
Bhavna Prakash,
Aye.
Deborah Snow.
Aye.
The motion carries. Thank you. All right, Ms. Dillon.
Moving on to item 15E, AB 742, Department of Consumer Affairs licensing applicants who are descendants of slaves. This bill was introduced on February 18th, 2025, and is located in the Senate Committee on Appropriations. This bill would require those boards to expedite applications for applicants seeking licensure who are descendants of American slaves once a process to certify descendants of American slaves is implemented. This bill would make these provisions operative only if SB 518 is enacted, establishing the Bureau for Descendants of American Slavery, and would make these provisions operative when the certification process is implemented pursuant to that measure. SB 518 would require the Bureau, as part of its duties, to verify an individual's status as a descendant and would require proof of an individual's descendant status to be a qualifying criterion for benefits authorized by the state for descendants. AB 742 would repeal these provisions 4 years from the date on which they become operative or on January 1st, 2032, whichever is earlier. And at its April 21st, 2025 board meeting, the board took an opposed position on this bill.
So are we still opposed as a board? I think we're still able to process sort of applicants within a 30-day time frame. So for all groups, I'm not sure if there's any potential, if it's advantageous for us to support the bill, given how quickly we can process licensees through our system. A testament to Rosanna Khan and her team's ability to get it done so quickly. Is there anyone who has a disagreement with our position as opposed? Okay, thank you, Ms.
All right, so moving on to item 15G, Senate Bill 470, Bagley-Keene Open Meeting Act teleconferencing. This bill was introduced on February 19th, 2025, and is located in the Assembly Committee on Appropriations. This act authorizes meetings through teleconference subject to specified requirements, including that the state body post agendas at all teleconference locations, that each teleconference location be identified in the notice and agenda of the meeting or proceeding, that each teleconference location be accessible to the public, that the agenda provided an opportunity for members of the public to address the state body directly at each teleconference location, and that at least one member of the body be physically present at the location specified in the notice of the meeting. This act repeals these revisions on January 1st, 2026, and the bill would instead repeal these provisions on January 1st, 2030. And at its April 21st, 2025 board meeting, the board took a support position.
I think I'm in favor of a support position. Is anyone in disagreement with that? All right, hearing none. Thank you, Ms. Dillon.
All right, and finally, item 15H, SB 641, Department of Consumer Affairs and Department of Real Estate, States of Emergency Waivers and Exemptions. This bill was introduced on February 20th, 2025, and is located in the Assembly Committee on Appropriations. This bill would authorize the Department of Real Estate and boards under the jurisdiction of the Department of Consumer Affairs to waive the application of certain provisions of the licensure requirements that the board or department is charged with enforcing for licensees and applicants impacted by a declared federal, state, or a local emergency, or whose home or business is located in a declared disaster area, including certain examination, fee, and continuing education requirements. This bill would exempt impacted licensees of boards from the payment of duplicate license fees. The bill would exempt a licensee whose home or business mailing address is located in an area of which a federal, state, or local emergency or disaster area is declared from the penalty for failing to notify their licensing agency within 30 days of a change in their mailing address. This bill would require all applicants and licensees of the Department of Real Estate or boards under the Department of Consumer Affairs to provide the board or department with an email address. And at its April 21st, 2025 board meeting, the board took a watch position on this bill.
So are we still at a watch status for this bill? Looks like I'm seeing a lot of nods in favor of that. Okay, so we'll continue with the watch position.
All right, perfect. And that concludes the update.
Thank you, Ms. Dillon. Really appreciate that.
Thank you.
Are there any questions from the board regarding any of the legislative updates? Hearing none, are there any comments from the floor? Are there any comments from WebEx?
Thank you, Mr. Board President. If any member of the public would like to comment on agenda item 15, please raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no request for comment. I return the floor back to you.
Thank you so much. And I just want to appreciate Michael Knotes for his guidance here. So thank you so much for that. Agenda items for the next meeting. Rosanna, board members, feel free to chime in. Is there anything else we should be including on the agenda for the next board meeting in November?
Just our regular setting the meeting dates for the next calendar year.
Okay.
And then you did mention regarding the practice agreement.
Yes, we will be establishing a practice agreement review committee, and I'll have more specifics on that in the next board meeting. And we'll be looking for volunteers from the board. Thank you. And we are now entering, I'm sorry, are there any public comments in the room or on WebEx?
Thank you, Mr. Board President. If any member of the public would like to comment on agenda item 16, please raise your hand. We'll give you a moment. All right, I see no request for comment. I return the floor back to you.
Thank you so much, Madam Moderator. This is agenda item number 17. We will be entering closed session. The closed session is intended for discussing disciplinary matters. As noted in the materials, once we move into closed session, the meeting will adjourn from within the session and will not be broadcast. Thank you, everyone, for your attendance and engagement during this board meeting. It is greatly appreciated, and we will close out the board meeting at a record time of 10:40. Thank you.